The Law Society of Kenya, LSK, has filed an application seeking the court to set aside the conservatory orders that bar public institutions from engaging private legal practitioners. Addressing the media in Nairobi on Tuesday, LSK president termed the move unconstitutional, discriminatory, and a threat to access to justice. Joseph Wahungo compiled this report.
The conservatory orders issued on Monday by Justice Samuel Mukira at Nakuru High Court temporarily halted public entities from hiring external legal counsel. This followed a case filed by Gikenyi Magare and Busia Senator Okiya Omtata challenging the use of substantial amount of money on legal fees for private counsel despite having competent and experienced lawyers. However, LSK says the order unfairly targets the legal profession, while other professionals such as doctors, engineers, and architects continue to be engaged by government agencies.
The petition and ex parte orders granted by the High Court sitting at Nakuru petition E001 of 2026, are a culmination of a protracted cyclic attempt to cut off private practitioners from the public sector economic ecosystem.
We have since filed an application seeking to review and set aside the ex parte conservatory orders issued by the Honorable Mr. Justice Mohochi Mukira and are hopeful that this regrettable omission in law will be rectified swiftly.
Speaking in Nairobi on Tuesday, LSK President Faith Odhiambo argued that the issue had already been settled through previous court rulings and Senate deliberations, which affirmed that public bodies are legally allowed to outsource legal services when necessary. According to LSK, public institutions often lack the capacity to handle the sheer volume of complexity of cases they face, making the engagement of private lawyers unavoidable to prevent case backlogs and default judgments.
And therefore to single out the entire legal profession of the entire country is not only absurd, illegal, and unconstitutional.
Why discriminate on one profession, on one body of profession? That is the question that we are asking. It is completely preposterous.
The society also dismissed claims of excessive legal fees, saying advocate remuneration is regulated by law and subject to assessment by courts and procurement processes.
It is therefore untenable to suspend legal services altogether in the name of capping expenditure on legal fees, as the law provides adequate avenues through which fees can be regularized.
Joseph Wahungo for Prime Edition.